morning, my lords and my lady, draw your attention to the fact that under Article 10, the subtitle is National Values, and more importantly for the proceedings that we have before you, National Values and Principles of Governance. Article 10 then spells out, 10.1 spells out how it applies and how it's supposed to be interpreted and applied. My interest is drawn specifically to Article 10, Subarticle 2, which says the national values and principles of governance include, then there's A, B, C, and D. Now, those are not mere wishes. Those are the expressions of Kenyans saying that if you are to be a leader in Kenya, then you must lead on the basis of those values. I, for the sake of what is before us, draw our attention to Subarticle 10.2c, which talks about good governance, integrity, transparency, and accountability. Why do I say that? Because impeachments are founded on the basis of good governance, founded on the basis of integrity, transparency, and accountability. My lords and my lady, Kenyans, being fully cognizant of the high authority, high moral authority that they wanted from their leaders, did not stop there. They still, under Chapter 6 of our Constitution, went on to provide for 8 additional articles. The 8 additional articles, my lords and my lady, speak to the leadership and integrity of the leaders. The specific title, my lords and my lady, is Leadership and Integrity under Chapter 6. Article 73 talks about responsibility of leadership. Of significance for purposes of our submissions today, I would want to draw your attention to 73.1, which says authority, responsibility, that is authority assigned to a state officer, is a public trust to be exercised in a manner that then the people of Kenya spell out what they expect of their leaders. Of interest to me is what appears at Subarticle 1A, Roman 3 and 4. Roman 3 speaks of brings honor to the nation and dignity to the office. At Roman 4, it says promotes public confidence in the integrity of the office. Chapter 6 then goes on to provide for many other ways of dealing with leaders at different levels of leadership within the country. Now, again, under that very Chapter 6, Kenyans then make it a cardinal and mandatory requirement that for any public officer to assume office, they must take an oath of office. Now, that oath of office is the epitomization of a social contract that I was speaking to. That oath of office, my lords and my lady, takes different forms depending on the office that one is supposed to be assuming. In the context of a president and deputy president, at Schedule 3, that is the third schedule, there's a very clear indication as to what that oath is supposed to be. It says, I, so and so, in full realization of the high calling, I underline high calling, I assume as the president or acting president or deputy president of the Republic of Kenya, do swear or solemnly affirm, the Constitution makes you to swear to the people of Kenya, that I will be faithful and bear true allegiance to the Republic of Kenya. It also says that I will obey, preserve, protect, and defend its constitution, this Constitution of Kenya, as by law established, and that all laws, all laws of the Republic, and that I will protect and uphold the sovereignty and integrity and dignity of the people of Kenya. I underline protect and uphold the sovereignty, integrity, and dignity of the people of Kenya. A similar oath of allegiance is provided for by the Deputy President. When you get time, my lords and my lady, you'll take an opportunity to look at the nature of the oath. What is the significance of these oaths? My lords and my lady, we submit that the oaths are a solemn commitment by the leaders to uphold the Constitution. It also creates public and moral binding commitment to uphold the sovereignty, integrity, and dignity of the people. And more importantly, that it is the accountability pledge in the social contract that I spoke to. At a later part of my conversation, or rather my submission this morning, I'll refer us to the consequences that the failure to adhere to these conditions or the terms of engagement would lead to in respect of leaders at one level or the other of government. Of interest, and just to show how significant the question of the integrity and this commitment to these articles, I mean the provisions of Article 10 and Chapter 6 are, the President, upon assuming office under Article 132 of our Constitution, is given a duty which is akin to reporting on how they are performing. Under Article 132(1)(c), which under the title Functions of a President, it says, once every year, report in an address to the nation on all the measures taken and the progress achieved in the realization of national values referred to in Article 10. It means a responsibility is put on the President or on the President to then report on the measures they've taken in the realization of Article 10. That just tells you how significant how important that provision is to the people of Kenya. Now, that defines to a large extent how the executive arm of our government works. The people of Kenya then do not stop at that. They say that in order that we hold you accountable, we must then have an arm of government that deals with or that keeps you on check, that exercises oversight over these elected leaders. Now, it is important to then make reference to Article 1, Subarticle 2, that the people of Kenya can make these sovereign decisions either directly or through their democratically elected leaders, so that then the source of authority for parliamentarians, for instance, is as a result of being the democratically elected leaders. And I'll speak to why that is important. I draw your attention, my lords and my lady, to Article 93 of our Constitution. Article 93 of our Constitution establishes our parliament. That our parliament consists of the National Assembly and Senate. Now, at Article 94, the people of Kenya go on to determine what the role of parliament is. My lords and my lady, I am sure we'll have an opportunity to read the entirety of Article 94. But for purposes of a presentation that we are making before you and the submission, I draw your attention to the provisions of Article 94, Subarticle 2. It says, the Parliament manifests the diversity of the nation, comma, manifests the diversity of the nation. It means that is where every single section or, if you wish, person or member of any class in Kenya is represented in Parliament. It takes into account the minority. It takes into account each and every community in Kenya. It goes on to say, it manifests the diversity of the nation, says, represents the will of the people. Read this in the context of Article 1, Subarticle 2, that Parliament represents the will of the people. That when parliamentarians speak, they do not speak as parliamentarians. They speak representing the will of a people. And more importantly, under that 94(2), and exercises their sovereignty. Again, read in the context of Article 1, Subarticle 2, it gives those people, the parliamentarians, the power to exercise the sovereignty of Kenyans. Now, this is a complete surrender in the constitutional sense, that Kenyans surrender their rights to their democratically elected leaders to be able to make decisions on their behalf. And from a craftsmanship point of view, one would want to argue that once we have elected our leaders, we cannot, every time we think there's an infraction of any aspect of a constitution, we then call Kenyans into a plebiscite. That is why we have leaders who then, in the event that there's such an issue, can speak for the people of Kenya. Now, I then draw your attention to the provisions of 94 94.4, that which says that Parliament shall protect this Constitution and promote the democratic governance of the Republic. Again, promote the democratic governance of the Republic. The Constitution then, under that Chapter 8, goes on in a slightly more granular sense at Article 95 to say, that is the role of National Assembly, to say the National Assembly represents the people of the constituencies and special interests in the National Assembly. In particular, I would draw your attention to 95, Subarticle 5, which says, the National Assembly reviews the conduct in office of the President, the Deputy President, and other state officers and initiates the process of removing them from office. My lords and my ladies, that article does not give us any option. It says the representatives will review the conduct of our elected leaders, separation of powers. If they find that any of the conducts does not fit within the confines of Article 10 and Chapter 6, then the instructions from the people of Kenya is very clear. Initiate the process of removing them from the office. Role of Senate at Article 96. I refer, my lords, to Article 96, Subarticle 4, that the Senate participates in the oversight of state officers by considering and determining any resolution to remove the President or Deputy President from office in accordance with this, with Article 145. My lords and my lady, why is this important? It is important because we see a textual commitment, and this was a submission made by learned Senior Counsel Githu Muigai. There's a textual commitment of this oversight responsibility to the parliamentary arm of government, that is the legislative arm of government. We then are drawn to maybe just so that I conclude that an explanation under Article 96. Now, this oversight is exercised in differently in different jurisdictions. In Kenya, the Constitution at Article 145 and Article 150 dictates that it is through impeachment. In other places, it is through a vote of no confidence. Both those processes, as submitted by learned Senior Counsel and with the support of authorities, are political processes. That's why it is important for us that we appreciate why we appreciate the defining four corners of an impeachment proceeding and the role then subsequently of the court. I also add that the manner in which this legislative arm of government exercises its authority is by, number one, deliberating, as we saw in the proceedings before the National Assembly, as well as in the proceedings before Senate. They deliberate, they interrogate, they question. After they've taken an informed position, my lords and my lady, they vote. That is how parliamentarians make their determinations. Now, that is how they express the will of Kenya. That is how they express the sovereignty of the people of Kenya. It then follows that a test that is to be applied in determining whether that exercise of that will and sovereignty was done properly can only be a political test, and I explain why. If we, for instance, conflate that test to be a test in the judicial sense, then the Article 10 and the values that it ascribes, then it immediately run into challenge. Because when we say, for instance, good morals, how will the court determine good morals other than by being subjective? There's no standard through which the court would say this is a good moral, this is a bad moral. That is why the people of Kenya say our elected leaders will determine that for us based on those specific provisions of the law. I want to give this in the context of Article 145, Fred Mutatis Article 150. Look at the grounds of impeachment, for instance, under Article 145. One of the grounds is that the existence of, or rather serious reasons to believe that the president or the deputy president, as the case may be, has committed an offense. Now, from a political perspective, the test is purely a prima facie test. I'd be looking at, having listened to what has been presented, what do I make of it? Having heard what has been said, what do I make of this judgment from a morality perspective? If that same question was to be presented to the court, then there are defined standards. For instance, in relation to issues criminal, it is beyond any reasonable doubt. So it means those two tests, if we were to conflate them, then we will be judging a political process through what I would otherwise call a wrong lens. And that is, again, to be supported by the decisions in by the Supreme Court of Philippines, as well as the decisions in our own cases of the Court of Appeal in Martin Nyaga Wambora and 3 others versus the Speaker of the National Assembly, where the court says that courts have neither jurisdiction to initiate a motion, consider a resolution, nor hear charges against impeached officer. The province of the court is solely to decide on the rights of the individuals, not to inquire how Parliament performs its discretionary duties. I dare add, when a vote is presented to you, my lords, there is no requirement that a parliamentarian or a member of the National Assembly voting one way or the other assigns a reason as to why they voted, how they voted. That vote is assumed for all intents and purposes to be the expression of the people who elected that person to that National Assembly or to the Senate, as the case may be. That is the same position taken by the Supreme Court in the Sonko case, which is part of the decisions that we've cited in our bundle and list of authorities. The court then says, courts should be slow to interfere with the exercise of parliamentary discretion, and the mandate of the courts is restricted by the doctrine of a separation of powers to deciding on individual rights and fundamental freedoms. In other words, the processes that were undertaken by the legislative arm of government. Now, I want to draw inference just to make this point sink. Let's look at the provisions of Article 144, for instance, where the president could be removed from office for incapacity. Now, the process goes on. At the tail end of it, Article 144, subarticle 8, yes, Article 144, subarticle 8, the ultimate test is that the report of the tribunal shall be final and not subject to appeal, and if the tribunal reports that the president is capable of performing the functions of office, the Speaker of the National Assembly shall so announce in the National Assembly. Now, what is important to draw here is that the people of Kenya are deliberate about saying these processes should be shielded from the court process. And that is the political component of these processes. And why is that important? We come from a history, my lords and my lady, where issues touching on the presidency have taken more than 5 years. In fact, we've had to go to subsequent elections when those matters were still pending in courts. Yet they are matters that are purely political in nature. My lords, for those reasons, the people of Kenya are very deliberate. It's not an omission. They're deliberate that they would want to omit the courts from that political process. Now, having outlined that constitutional architecture, we then draw our minds to how did we, or how did the National Assembly conduct the impeachment process that is the subject of this trial and these proceedings this morning. My lord, my lady, this is to be found in the affidavit of Samuel Njoroge, specifically paragraphs 9 to 28. Now, the test or the consideration that the court will be looking at is the manner in which the National Assembly complied with the provisions of Article 150, read with Article 145, mutandis. Now, number one is the question of establishment of the grounds. The grounds are under Article 145(1). I need not read them. What is important, though, is that once a member of parliament presents a motion in the nature of Article 145, that is for impeachment of the president or a deputy president, as the case may be, then the Speaker of the National Assembly would have to satisfy himself on a number of threshold questions. I'll refer you to where this was done. Now, the first item that the Speaker looks at is whether, as framed, the grounds that have been presented in Parliament meet the grounds in Article 145. That is, I think, to be found in the Standing Orders number 64.1, which defines how that motion is supposed to be made. It says in a very granular sense that it is supposed to be in writing, and number two, it must spell out the grounds that are articulated in Article 145. Standing Order number 64.1A then goes into looking at the manner in which the Speaker reviews those grounds as to whether they fit within the constitutional architecture. And that is a role that is under those specific standing orders left for the Speaker of the National Assembly. My lords and my lady, I'll draw you and I'll probably point you in the course of my submission to the findings of how the Speaker of the National Assembly deals with those requirements. But the sum of it is that the Speaker of the National Assembly satisfies himself at page 745. Let me just try and get the page 745. As to the two tests, both under Standing Order number 64.1 and Standing Order number 64.1A, that both those conditions have been met. Now we go to the second test, and I'll take you just in a short moment to the Hansard to speak to this. We go to the second test, which is the threshold test. Now, the motion must be supported by at least, in the words of the Constitution, if a motion under clause, a member of the National Assembly supported by at least a third of all the members. So the first threshold test is that the motion is supported by at least a third of all the members. I'll draw your attention to how the Speaker of the National Assembly deals with that, determining that question. He makes an express finding that all the members refers to all the members elected, and he gives a specific number as to what all the members mean. He then gives a mathematical representation that for that threshold to be met, there must be at least 117 members supporting the motion that is presented. In the case at hand, my lords and my ladies, the number of people who supported the motion was 282. 291, members of the National Assembly supported the motion presented by the member for Kibwezi. Now, the second test is under Article 145(2), which says, if a motion under Clause 1 is supported by at least 2/3 of all the members of the National Assembly, now the second threshold test under Article 145 subarticle 2 is 2/3 of all the members of the National Assembly. Again, the Speaker of the National Assembly, at the conclusion of that exercise, makes a finding as to the number of people who supported or voted in support of the motion. In particular, they say 291 out of 349 members voted in support of the motion. That is what learned Senior Counsel Professor Gideon Muigai referred to as a super majority. My lords, in terms of compliance, those three thresholds are fundamental. I want to take a quick moment to just draw your attention to the specific area where this is to be found in the communication from the chair. Yes, I'm there, my lords and my lady. The Hansard runs from page 744 in volume 2 of the annexure SN3, the affidavit of Samuel Njoroge. My Lords, my Lady, after identifying the specific issues of concern, the Speaker at page 748 says, having examined the notice of a special motion by the member for Kibwezi West, I find the special motion meets the requirements relating to the form and threshold set out in Articles 145(1) and 151(b) of the Constitution and Standing Order 64. Then goes on to say, I have also satisfied myself that the number of members who have appended their signatures in support of a special motion exceed the minimum threshold of 117 members. Then further on it says, having determined that the special motion is admissible, let me now focus on the next step of giving notice to the special motion to the House. Under Standing Order number 47, 4A, which provides that with respect to the motion of removal from office, a member shall give notice of a motion in the House within 3 sitting days following the approval by the Speaker. Now, that, my Lords and my Lady, when you get an opportunity, is how the Speaker of the National Assembly deals with the threshold questions. We submit on behalf of the National Assembly that those thresholds were met. After meeting the thresholds, what then do we address our minds to? We stop there, my Lords and my Lady, to ask ourselves a number of questions that arose in the course of the presentation before you. Learned Senior Counsel Paul Muite, supported by Counsel Mr. Kibe Mugai, Mr. Ndegwa Njiru, and even Mr. Ogada, described the pace at which the impeachment process was done as a breakneck speed. My Lords and my Lady, where does the pace, or what determines the timelines within which impeachment is supposed to be done? A reading of the entire Article 145 gives a total of 19 days within which the impeachment process should have been completed. And my Lords and my Lady, that said, if you calculate the 2 days, the 7 days, and whatnot, it gives you a total of 19 days. That said, my Lords and my Lady, the question of the timely and expeditious determination of an impeachment motion is a dictate of the Constitution. It is not a whimsical escapade or undertaking by the either National Assembly or the Senate. Those timelines are cast on stone, and they must be done within those timelines. Now, it is not unique when we're dealing with issues touching on the presidency because of the sensitivity of a presidency to a republic. Under Article 145 of 140 of our Constitution, any question as to the validity of election of a president is determined within 21 days. Again, under Article 144, a motion for removal of a president for incapacity is to be determined within 30 days. What do we read from these very tight timelines? We read the history that we've walked, that in dealing with these matters, which are obviously possibly divisive and also very contentious, if you leave parties to attend to those processes as they would, we would not be able to make those determinations within the contemplated timelines. My Lords and my Lady, that is the nature of our Constitution. Learned Senior Counsel Paul Muite then also submits that impeachment is a nuclear option and should be the last resort in dealing with disciplinary issues around a presidency. I mean, around dealing with impeachment of a president or his deputy. My Lords and my Lady, contrary to that, Article 10 and Chapter 6, couched in very mandatory terms, speak to what I'd call the political hygiene of the country. They determine what follows, and remember in the course of my presentation, I said I'll revert back to Chapter 6. At Article 75, my Lords, 75(5) says, no, 75(3), sorry. a person who has been dismissed or otherwise removed from the office for contravention of the provisions specified in Clause 2 is disqualified from holding any other office. That is an important dictate of the Constitution. It doesn't give us an option. It means in black and white that to the extent that His Excellency the Deputy President was found to have been in breach of this Chapter 6, specifically the ones referred to Clause 2, which is to be read with Article 10 and Article 73. Once he is impeached, the Constitution says he is disqualified from holding any office. I underline any office. It is not just about the presidency, it is about any public office. And I think that answers the question that learned senior counsel posed to this court. It will be an office either at the national level, at the county level, at the constituency level, and I dare add, even at the county assembly level. Any office that is defined under Article 260 of our Constitution, the test being a simple one. Will that office require that the payment to that office holder be made from the consolidated fund? So the long and short of it, my lords and my lady, is that this article is a bar, unless changed through any other process, is a bar to His Excellency the Deputy President from holding any office, any public office. I go to the next question around fair hearing. This was submitted to quite at length by my learned and good friend, Mr. Dudley Ochiel. I want to add that from a factual perspective, and this is available in the Hansard, each of the senators, each of the members of the National Assembly was presented with the volumes or the documents that contained the petition, the first respondent, His Excellency Rigathi Gachagua, then the Deputy President, was given an opportunity to respond, which, again, as you will see from our Hansard, he very ably responded to in writing. He was again given an opportunity to attend in person before the National Assembly and before the Senate. Again, he seized that opportunity and attended. He did not just attend alone, he attended with a battery of at least 14 lawyers. That is what the law contemplates. Now, the lawyers were given an opportunity to ask questions, and the Hansard will bear me witness. I'll refer you to the specific aspects of the answer. That the lawyers representing the Deputy President then had very robust engagement, questioning each and every of the grounds that was represented or that was tendered for purposes of the impeachment. After that, the members of the Senate, just like in the National Assembly, were given an opportunity to ask questions. Why is that important? It is important because it shows that these two houses were given an opportunity to interrogate. And interrogation here is so that they're able to make informed decisions. My learned colleague Moses will address us at a later stage on the question of public participation. You will see how that public participation played in. The only point I would want to make is that when that public participation was conducted, it was conducted so that the members of the National Assembly and Senate alike could touch base with the people they represent to see what their thoughts were in relation to the question of impeachment. It is not for this court, I add. It is for the members of the National Assembly and the Senate, as the case may be. Now, is that a case of somebody who was not afforded an opportunity to be heard? My lord and my lady, that brings me to the central question in relation to that issue. The central question is in relation to the adjournment that was declined by the Senate. Let me say this. I will refer you to the provisions, or rather to the recordings in the Hansard, on how the application for adjournment was made by learned Senior Counsel Paul Muite. My lord and my lady, it is apparent from those proceedings that no ground or no evidence was presented before Senate to enable them, to support the exercise of discretion. With the material that was available before Senate, they made a determination on the basis of the fact, and they did ask this, that the proceedings before the House were time-bound proceedings. They put a specific question to learned Senior Counsel Paul Muite. What do you want us to do? My lords and my lady, I refer you to the specific answer that was given by learned counsel Paul Muite. Now, not a single piece of paper was presented to the Senate for them to be able to make a determination as to the allegation of ailment. Why is that important? It is important for this reason. The petitioners have come before you to try and question the exercise of discretion of the Senate in denying the motion or the application for adjournment. It is very clear that whilst in Senate, they did not tender any material to support that application. I underline any material. Learned Senior Counsel, the Honorable James Orengo, and this is captured in the Hansard, speaking to this same process, says at the very least, he would have expected at least a doctor from Karen Hospital to come and confirm to the Senate the condition of His Excellency, the Deputy President, then. That did not happen. That, my lords and my lady, we are seeing an affidavit emerging from the woodworks today. Of what probative value? If you're being invited, my lords and my lady, to evaluate the material that was before the Senate at the point at which they were making that determination declining the adjournment, what is the value of an affidavit being filed before you today to support that application? My lords and my lady, it must be abundantly clear that that application is not being made before this court. This court is merely being invited to review the manner in which Senate exercised its discretion. I dare add that absent any supportive material, then Senate had absolutely no basis of granting the orders that were sought. My lords, it should not be lost that even in Senate, and this is also evident in the Hansard, the petitioner, His Excellency, the Deputy President, then Rigathi Gachagua, was represented by a team of 14 lawyers. That is on record. My lords and my lady, are we saying that out of these 14 lawyers, none of them would have imagined that it is important to lay a document to satisfy the Senate or to give grounds for the adjournment that they were seeking? We think that is a far cry. That was a deliberate omission. This court cannot now go into looking for reasons that ought to have been looked at, or items or material that ought to have been looked at by the Senate, but which were never quite placed before the Senate. It means that the affidavit that has been presented by Dr. Dan Gikonyo before the proceedings, to support the proceedings before you, is of absolutely no value, because no material can be introduced. And I would equate it to the court proceedings. My lords and my lady, if I was to make an application before you today, my team leader, learned Professor Githu Muigai, is not in, and I just say, I want us to adjourn these proceedings, important as they are, then I tell you, I suspect that is unwell. Chances are the court will say no. If the court says, I have not established the grounds for grant of that adjournment, would it be open for me to now go to the Court of Appeal to say that I now have a document 1.5 years after the application has been made? I want you to look at this affidavit. It confirms indeed that the person in issue was actually unwell. That material, having been missing in the proceedings before Senate, cannot be used as a basis of making a determination on that on the exercise of that discretion one way or the other. My lords and my lady, I would want to very quickly, I'd said I'll refer the court to various areas within the Hansard that speak to these items. In the third and fourth respondents' annexures, marked as Part 4, this big volume, unfortunately it's not paginated, they are the proceedings of the Senate, specifically at page 7, where Learned Counsel Paul Muite makes the application for adjournment, and it runs all through to page 15. My lords and my lady, I ask that when you get an opportunity, just read for yourselves, and you see the deliberations as they unfolded before the Senate. There's then the communication by the chair of the Senate, which appears at page 15 after that of the same document. Again, the reasoning of the Speaker in relation to the question of adjournment, ultimately putting the matter for resolution by the whole House. My lords, that is the part of this Hansard which speaks to how the application for adjournment was made. I need not read the whole of it in the interest of time. I'm sure the court will find an opportunity to read that. I think I'd refer the court to the specific parts of the Hansard from page 744 of volume 2, annexures running from page 711 to page 1301, specifically page 744 running through page 746 up to page 749. My lords and my lady, that is how the National Assembly deals with the issue of the issue of threshold. Yes, my lords and my lady. So we then ask, on behalf of the National Assembly, that you find that the petitioners have not met the threshold for you to exercise the review that they're inviting you to exercise. I want to add, as I mentioned earlier, that the review that is supposed to be before you is a review of a determination arising out of a vote. Is it the sort of review that is contemplated in these proceedings? I say, or I add one point to that, that because the members of the National Assembly, the members of Senate, are not required under Article 1, Subarticle 2, to give the reasons as to why they voted however they voted, what would be this reason that would be testing if we were to apply a test, for instance, of Wensbury and reasonableness under the anisminic sense? There'll be no reason that you'll be looking at. From a political sense, my lords and my lady, the only solution left is by the people then saying that that specific member of the National Assembly did not express our will. We will deal with them in two ways. The Constitution says either you deal with them at the point of re-election or you deal with them through a recall, not in the manner in which we seek to want to, in a granular sense, lay blame on the findings of the members of Senate. I pray that the petitions be dismissed. May I now cede the ground to my learned friend, Mr. Mushemi, to make his presentation. I'm most obliged.
Thank you, my lords and my lady. My name is Michael Mushemi. I appear for the 9th respondent. Your lordships, we are relying on our replying affidavit dated the 22nd of October 2025. Our submissions dated 15th February 2026. Our supplementary submissions and list of authorities dated 5th of May 2026, and our further list of authorities dated the 12th of May 2026. Very briefly, my lords, since the enactment of the 2010 Constitution 16 years ago, Parliament has only met the threshold of 2/3 majority on any bill or any motion on 2 occasions. The first of these occasions was during the passing of the BBI bill, the now defunct bill, where on the 7th of May 2021, the National Assembly approved that bill with 224 members in support and 63 voting against. And in the Senate, on the 11th of May 2021, with the bill being passed by 51 members, 11 voting against and 1 abstention. My lords and my lady, my client, the 9th respondent, brought this motion pursuant to Article 145(3), and in historic numbers, first as required by the Constitution to garner 117 signatures, he was able to garner 290 signatures of members of the National Assembly to present this motion. And when the motion was tabled on the 27th of September 2024, and subsequently debated on the 8th of October 2024, as has been submitted by my learned colleague, Mr. Gumbo, the motion was supported by 282 members, representing 80% of the whole House. This was not just a majority, but a supermajority. When the motion went to the Senate, and the vote was taken, and I'll only rely on one ground number 1, 54 members voted for the motion, 12 against, and 1 abstention. My lords, you have been told that Parliament acted as a lynch mob, but there has never been occasion in the 16 years that this Constitution has existed that Parliament has voted on such numbers. If that were the case, you would have been given instances or other examples where Parliament has acted in this manner. And the reason these numbers were achieved, supermajority in both houses, and you will see that they exceed the BBI numbers. In fact, in the National Assembly, they exceed by almost 60 members of the National Assembly, is because of the weight of the 11 grounds of impeachment. My lords, it is our submission that in our country, there is no country anywhere in the world with a higher threshold of impeaching a president or deputy president in this case than this country. If you go to the United States, for example, in the House of Representatives, which is the lower house, you only require a simple majority to approve the articles of impeachment. It is in the Senate that you thereafter require 2/3. If you go to the Philippines, and here we are comparing presidential systems, you require 1/3 of all the House members to endorse the complaints and 2/3 of the Senate. Nigeria has a system such as ours, and so does Brazil. So it is our submission that the safeguards provided by our Constitution are adequate to ensure that this process is not abused. Our Constitution further requires public participation, and this requirement now sets it apart from those examples that I have given you, where impeachment is handled solely by elected representatives. And as will be submitted by my colleagues, public participation was conducted across all constituencies in Kenya throughout this process. So in fact, my lords, we have no comparative in the world. We have the most progressive and advanced constitution in the world when it comes to impeachment of the president. The argument by the petitioners that either Parliament acted as a lynch mob is again not true. The argument that the Deputy President was elected by the people, whereas is true, the contra-argument is that he was also sponsored by a political party to run for office. He ran for office as Deputy President under the banner of a party called the United Democratic Alliance, UDA. And my lords, under Article 38 and under Article 91, political parties are the foundation of our constitutional democracy. In the National Assembly, at the time the Deputy President was being impeached, the UDA had 144 members of the National Assembly. Out of those, 114 voted to impeach the Deputy President, with 21 voting against. And it is our submission that it is clear that he had lost the confidence of his own political party to continue holding office. Our colleagues have cited numerous authorities from South Africa, and South Africa is a good example of how leaders respect decisions of political parties. President Mbeki in 2008 resigned after he was recalled by his own political party. He was not heard by the party. He was not invited to any hearing. The party just met and said they had lost confidence in him. This decision was submitted to him, and he said that he respects the decision of the party, and he resigned. The same thing happened to President Zuma, who resigned on Valentine's Day of 2018. And the following day, President Ramaphosa was sworn in. The party simply said, "We have lost confidence in you." Closer home here in Zimbabwe, when President Mugabe was removed as leader of ZANU-PF on the 19th of November 2017, again he opted to resign because he was going to face an impeachment vote. Parliament is often considered the highest form of representation in a democracy because it serves as a primary venue where elected members represent the diversity, will, and sovereignty of the people. It is our submission, Your Lordship, that the first petitioner not only lost the confidence of Parliament, but he had lost the confidence of the political party that sponsored him to run for political office. My Lords, you have been told a lot about the grounds of impeachment. And in Article 145, the framers of our Constitution and the context of our Constitution has to be read in its plain text. They gave 3 grounds for impeachment, and they said gross violation of a provision of this Constitution, and where there are serious threats of believing that the President has committed a crime, and for gross misconduct. There was very good reason for the drafters to give these 3 reasons, because they were not to subject the President or the Deputy President to judicial standards by members of Parliament. They were not to subject them to judicial standards. The charges against the Deputy President, 11 of them, are not to be subjected to judicial standards. I know my colleagues will give you examples of how other presidents have been impeached. But presidents all over the world have been impeached for far lesser crimes, for far lesser transgressions than you have seen here in our country. Here the impeachment was on serious violations of the Constitution. I'll go to the grounds of the impeachment, my Lords. And you are told about subsidiarity. Ground number 6 of the impeachment, where the Deputy President was accused of crimes under the National Cohesion and Integration Act. Ground number 7, where he was charged with the economic crimes under the Anti-Corruption and Economic Crimes Act and the Proceeds of Crime and Anti-Money Laundering Act. And ground number 8, where he was charged with contravention of Section 29 of the Leadership and Integrity Act. You have been told that there should have been deference by the National Assembly to the institutions, that is NCIC, EACC, and the DCI, to allow them to investigate those crimes before Parliament could do the duty that they did. That is not true, and we are guided by a decision of this court by a 5-judge bench in petition number 295 of 2018, Philomena Mbete Mwilu versus DPP and others. This was a 5-judge bench, Justice Omondi, Justice Ngugi, Justice Tuyot, Justice Musyoka, and Justice Muite, delivered in 2019. And in this decision, particularly paragraph 379 of that decision, the judges go on to say, and this was a decision which the Deputy Chief Justice had challenged charges that had been preferred upon her by the DPP in the Chief Magistrate's Court. And the judges say that from the analysis, the following principles emerge. First, in the absence of an express statutory or regulatory provision requiring prior approval or sanction from another authority in order to prosecute a judge or judicial officer will face trial directly in the event that he or she is alleged to have committed an offense. However, and this is the second principle, where there is a specific legal framework for dealing with misconduct and or removal of judges, cases involving misconduct with a criminal element committed in the course of official judicial function or so closely proximate or linked to the judicial officer must first be referred to the body responsible and the disciplinary or removal process commenced. My Lord, it is our argument that this decision applies in this case. And the holding, in fact, was that while the DCI is not precluded from investigating criminal misconduct of judges, there is a specific constitutional and legal framework for dealing with misconduct and removal of judges. Consequently, cases of misconduct with a criminal element committed in the course of official judicial functions or which are so inextricably connected with the office or status of a judge shall be referred to the Judicial Service Commission in the first instance. Your Lordships, it is our argument that this applies even to the office of the President and the Deputy President, that where there is already a mechanism of disciplining them, then that mechanism ought to be exhausted first and not the other way around. In fact, our Constitution does not contemplate a situation where the President or the Deputy President would be facing organs of security which are appointed themselves by the President. And that is why the Constitution then provides this mechanism in Article 145 to discipline the President and the Deputy President and to hold them account through their removal by Parliament. This position was supported by several other authorities, and there is an article I will urge you to read, the temporary criminal immunity for federal judges, that is contained in that authority. Secondly, Your Lordship, the petitioners argued, particularly in relation to ground number 9, that the National Intelligence Service ought to be under a civilian supervision. And whereas that is true, Article 239 provides that it is one of the national security organs, the other two being the KDF and the National Police Service. And in fact, in the composition of the National Security Council, and there are 9 people who sit in that council, it is only the Deputy President who is not appointed by the President, meaning that the Deputy President is very central to the running of that council. Your Lordship, it is our submission on the issue of fair hearing that the Deputy President in the National Assembly, and Mr. Gumbo has taken you through this, was present. He was represented by legal counsel. And I think the place you need to dwell on most is the Senate. It is my client's case that, in fact, prejudice in the Senate was suffered by the 9th respondent and the National Assembly. And why do I say this? This is because the first petitioner was able to present his case and his documents. He was able, through counsel, to cross-examine witnesses of the National Assembly, including the 9th respondent. But when the time came to cross-examine him, he was not available. So the prejudice was not on him, because his evidence was treated without any cross-examination. And you see